The Supreme Court has just signaled an emergency intervention that threatens to incinerate the entire bureaucratic apparatus of gun control in the United States. We are not discussing a minor revision of the statutory code. We are staring down the barrel of a total abolition of the government permission slip system. Every single purchase permit, every carry license, every FOID card, and every mandatory training certificate in all 50 states is currently on the chopping block. If you want to understand the mechanics of this legal demolition and how it impacts your ability to defend your life, you need to subscribe and hit that notification bell right now. The countdown has begun, and when this decision drops, the landscape of the Second Amendment will change irrevocably. The catalyst for this constitutional firestorm was a ruling from the Fifth Circuit that the legal establishment deemed impossible. A federal judge did not merely suggest reform. He issued a scorched earth injunction that halted the entire permit requirement of a state, declaring the very concept of licensing a right to be unconstitutional from its inception. The judge's opinion was not based on modern feelings, but on a cold, hard audit of history. He cited irrefutable records showing that between 1791 and 1900, not a single jurisdiction in the American Republic required a citizen to beg the government for permission to own or carry a weapon. But the ruling went darker. It exposed the dirty secret that gun control advocates are desperate to hide. The court found that when permit systems finally emerged in the early 20th century, the legislative records were explicit. These laws were designed specifically to disarm freed slaves and immigrant populations. The permit system was born out of racism, not public safety. When the state attempted to appeal this humiliating defeat, a 3-judge panel upheld the destruction of the law. And in a move that terrified the establishment, the full circuit court refused to review it, letting the precedent stand as the law of the land in that jurisdiction. This brings us to the weapon that is dismantling these laws, the text history and tradition test. This is the nuclear option provided by the Bruen decision, and it is currently vaporizing state regulations. The test is brutal in its simplicity. If a restriction did not exist in 1791, the government must prove there is a direct historical analog from the founding era. The court looked for these analogs and found a vacuum. The state could produce nothing. In fact, the historical record proved the opposite. Pennsylvania's 1776 Constitution explicitly protected the right to bear arms with 0 qualifications. Vermont's 1777 Constitution mirrored this, and Vermont has operated for 247 years without ever requiring a permit. The state attempted to cite the Statute of Northampton from 1328, an ancient British law, as their justification. The judge dismissed this immediately, noting that the statute only banned terrifying the king's subjects through threatening behavior, not the peaceful carrying of arms. The government's historical argument has completely collapsed, but the most shocking development comes from the Department of Justice itself. In a move that defies all political logic, the DOJ under the current administration filed a brief that serves as a death warrant for permit fees. They didn't just argue for lower fees. They argued that any financial barrier to a constitutional right is illegal. They invoked the 1966 Supreme Court case Harper v. Virginia Board of Elections, which banned poll taxes. The logic is undeniable. If you cannot charge a tax to vote, you cannot charge a fee to bear arms. We are talking about permit fees ranging from $50 to over $300, compounded by mandatory training rackets that cost citizens upwards of $500. The DOJ has essentially admitted that the current system is an unconstitutional poll tax on self-defense. They didn't stop at the money. The brief exposed the administrative nightmare of processing times. In New Jersey, the bureaucracy drags its feet for an average of 137 days. In parts of New York, citizens are forced to wait 180 days, half a year, to exercise a right that is supposed to be inherent. The denial rates cited are even more damning. In Los Angeles County, prior to recent interventions, the approval rate for carry permits was a microscopic 0.4%. In Hawaii, the state was issuing an average of 12 permits per year for the entire population. This is not a regulatory system. It is a prohibition masquerading as a process. While the federal government admits the system is broken, a coalition of 25 states has entered the arena with the data to prove that permits are unnecessary. These constitutional carry states have provided over a decade of real-world receipts that contradict every fear-mongering talking point of the anti-gun lobby. When Arizona shredded its permit requirement in 2010, the establishment screamed that blood would run in the streets. The result? Violent crime dropped 6% in 5 years, beating the national average. When Kansas adopted permitless carry in 2015, They were told it would be the Wild West. Instead, their murder rate plummeted by 11%. The ultimate test case was Texas. With 30 million people and major urban centers, critics said constitutional carry would cause chaos. The data shows the exact opposite. Violent crime in Texas dropped 4% in the first year and another 3% in the second year. The pattern is absolute across all 25 states. There is zero statistical evidence that requiring a government permission slip reduces violence. Furthermore, the coalition's brief highlighted the class warfare inherent in these laws. In Illinois, where the total cost to exercise your right hits $556, approval rates are 60% higher in wealthy zip codes. The permit system is effectively a tool to disarm the poor while allowing the wealthy to buy their rights. We are currently witnessing a judicial schizophrenia that has fractured the United States into two distinct legal realities. This is the constitutional emergency that has forced the Supreme Court's hand, the circuit split. Right now, the validity of your Second Amendment rights is entirely dependent on your geography, creating a balkanized legal landscape that stands in direct violation of the Equal Protection Clause. The Fifth Circuit has correctly identified that all permit requirements are unconstitutional. Meanwhile, the Second Circuit continues to enforce New York's draconian permit-to-purchase regime, and the Ninth Circuit has doubled down on California's discretionary dominance. We have arrived at a point of total absurdity where we have four conflicting constitutional standards for a singular Bill of Rights guarantee. Consider the legal liability of a citizen living in Louisiana under the protection of the Fifth Circuit. They possess an absolute right to carry for self-defense without government interference. If that same individual, possessing the exact same training, clean record, and moral standing, crosses the border into the Second Circuit's jurisdiction in New York, they are instantly transformed from a law-abiding citizen into a felon. Legal scholars describe this as a constitutional checkerboard, but let's call it what it really is, an entrapment zone for the unwary. The data generated by this split exposes the true nature of these systems. In the Fifth Circuit, permit applications plummeted by 89% immediately following the ruling. This wasn't a loss of interest. It was the realization of liberty. Citizens understood they no longer required a government permission slip to exercise a natural right. Contrast this with the Second Circuit, where New York processed over 438,000 applications last year, rejecting 34,000 of them. Thousands of lawful citizens were denied their rights based on subjective, arbitrary criteria, like insufficient need. The Ninth Circuit remains the most egregious offender, shielding California's system where sheriffs act as feudal lords, granting permits to political donors while disarming the general public. However, the most insidious threat is not what is happening in the courts, but what is happening behind closed doors in state capitals. Sources within multiple state legislatures have leaked intelligence confirming that anti-gun regimes are not waiting for the Supreme Court to rule. They are actively drafting workaround legislation designed to bypass the ruling before the ink is even dry. This is a coordinated conspiracy to maintain total control through rebranding and bureaucratic subterfuge. California is currently engineering the template for this resistance. Their draft legislation proposes the elimination of the permit, replacing it with a mandatory firearm safety compliance certification. Do not be fooled by the terminology. This certification demands the exact same background checks, the exact same exorbitant fees, the exact same training hours, and the exact same processing delays as the permit it replaces. The legal theory they are banking on is cynical and dangerous. They believe if they stop calling it a permit, they can evade the Supreme Court's ban on permitting systems. It is a distinction without a difference, designed to mock the judiciary. New Jersey's contingency plan is even more creative and obstructive. Their draft bill proposes eliminating carry permits, but replacing them with a mandatory ammunition purchase approval for every single transaction. Under this scheme, you might legally own the gun without a permit, but the state will force you into a 30-day waiting period every time you attempt to buy the fuel for it. This is a backdoor ban on functionality, turning your firearm into an expensive paperweight. New York is pivoting toward financial warfare with a proposed firearm liability insurance mandate. This would require every gun owner to maintain a $1 million liability policy. Insurance actuaries project these premiums will cost between $800 and $1,200 annually, far exceeding the cost of current permit fees. This is wealth-based disarmament, pure and simple. Illinois is drafting a public safety training verification system that monopolizes the training market, granting the state police the authority to artificially limit the number of approved instructors, creating a bottleneck that makes compliance mathematically impossible. Perhaps the most aggressive and dystopian scheme comes from Hawaii. Legislators there are considering a mandate that would force firearm owners to store their weapons at licensed central storage facilities, rather than in their own homes. This effectively deletes the concept of self-defense within the home, rendering the Second Amendment null and void where it matters most. Constitutional scholars warn that the Supreme Court must anticipate these bad faith maneuvers. To truly restore the Second Amendment, the court's opinion must be written with sweeping breadth, explicitly prohibiting any system, regardless of its name, that requires advanced government approval, financial tribute, or arbitrary delay before the exercise of a right. The Supreme Court is on the verge of a decision that will either abolish the permit state entirely or embolden a new era of creative tyranny. The anti-gun machine is already plotting their next move. If you want to survive the regulatory counterattack and stay ahead of the curve, you absolutely need to subscribe. Hit that like button and turn on notifications immediately, because I will be breaking down the text of the ruling and the inevitable state retaliation the moment it happens. Drop a comment below. Will the Supreme Court crush these workaround schemes, or will the states find a new way to legislate your rights into oblivion?